And we are back, flashing accept. Let's see. Hello. Article 105. Powers, privileges, etc. of the Houses of Parliament members, meaning committees thereof, subject to the provisions of this Constitution and the rules, standing orders regulating the procedure of Parliament. There shall be freedom of speech in Parliament. Clause 2 of Article 100. Member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in Parliament or any community thereof, and no person shall be so liable in respect of the publication of by or under the authority of the House of Parliament or any report, paper, votes, or proceedings. Clause 3. In other respect, the power, privileges, and immunities of each of House of Parliament and the communities of each House shall be such as may from time to time defined by Parliament by law, and until so defined shall be those of that House and of its members and community immediately before the coming into force of Section 10 of Constitution. Clause 4. The provision of clauses 1 and 2 and 3 shall apply in relation to persons who by virtue of this Constitution have the right to speak in and otherwise to take part in proceedings of a House of a Parliament or any committee thereof as they apply in Parliament. Okay. Salaries and allowance of members. Members of Article 106. Members of either House of Parliament shall be entitled to receive such salaries and allowances as may from time to time determined by Parliament by law and until provision in the respect is made the allowance at such rates and upon such condition as were immediately before the commencement of this constitution applicable. The case of the members of Constitute Assembly of the Domain. Yeah. Legislative procedure. Article 107. Provision and introduction and passing of clause 1 of article subject to the provision of article 9 17 to and other financial bills. A bill may originate in either House of Parliament To subject to provision of Article 108 and 100, a bill shall not be deemed to have been passed by the House of Parliament unless it has been agreed to by both houses either without amendment or with such amendments only as agreed by both houses. Clause 3. A bill pending in Parliament shall not lapse by reason of the prorogation of the houses. Clause 4. A bill pending in the Council of State which has not been passed by the House of the People shall not lapse on dissolution of the House of the People. 5. Clause 5. A bill which is pending in the House of the People or which, having been passed by the House of the People, is pending in the Council of State shall, subject to the provision of Article 108, lapse on dissolution of the House of the People. Article 108. Joint sitting of both houses in certain cases. If after a bill has been passed by one house and transmitted to other house, the bill is rejected by the other house, or the house have finally disagreed as to the amendments to be made in the bill, or more than 6 months elapse from the date of the reception of the bill by other house without the bill being passed by it. The President may, unless the bill has elapsed by reason of dissolution of the House of the People, notify the houses by message if they are sitting or by public notification if they are not sitting. His intention to summon them to meet in joint sitting for purpose of deliberating and voting on the bill. Provided nothing in this clause shall apply to money bill. Okay, so money bill, something different bill then. 2. In reckoning any such period of 6 months as is referred to in clause 1, no account shall be taken of any period during which the house referred in subclause E of that clause is prolonged or adjourned for more than 4 consecutive days. Clause 3. Where the President has under clause 1 notified his intention of summoning the houses to meet in joint sitting, neither house shall proceed further with bill. But the President may at any time after the date of his notification summon the houses to meet in joint sitting for the purpose specified in the notification. If he does so, the houses shall meet accordingly. Clause 4. If at the joint sitting of the two houses of the bill with such amendments, if any, as are agreed to in joint sitting, is passed by a majority of the total number of members of both houses present and voting, it shall be deemed for the purposes of this constitution have been passed by both houses, provided that at a joint sitting, subclause A, if the bill having been passed by one house has not been passed by the other house with amendments and returned to the house in which it originated, no amendment shall be proposed to the bill other than such amendments, if any are made necessary by the delay in passage of the bill. Clause B. If the bill has been passed and returned, only such amendments as aforesaid shall be proposed to the bill, and such other amendments as are relevant to the matter with respect to which houses have not agreed, and the decision of the person presiding as to the amendments which are admissible under the cause shall be final. A joint sitting may be held under this article and a bill passed that, notwithstanding that a dissolution of the House of the People as intervenes is the president notifies his intention to summon the houses to meet therein. Article 109 Special procedure in respect of money bills. A money bill shall not be introduced in the Council of State. Basically, the Council of States don't have, Rajya Sabha don't have the right to issue the money bill, actually. Clause 2 of Article 109. After a money bill has been passed by the House of the People, it shall be transmitted to the Council of State for its recommendation, and the Council of State shall, within a period of 14 days from the date of its receipt of the bill, return the bill to the House of the People with its recommendation, and the House of the People may thereupon either accept or reject all or any of the recommendation of the Council of the State. Okay, so the money bill shall be passed to the House of the Council of the State, and the House of the People can reject or accept the recommendation by Council of State. And why the fuck send it to the Council of State if you are gonna reject or accept it? Like it's like, okay, man, I'm just sending you, your opinion really doesn't matter. Clause 3 of Article 109. If the House of the People accepts any of the recommendation of the Council of the States, the money bill shall be deemed to have been passed by both houses with the amendments recommended by the Council of State and accepted by the House of the People. Clause 4 of the Article 109. If the House of the People does not accept any of the recommendation of the Council of State, the money bill shall be deemed to be have been passed by both houses in the form in which it has was passed by the House of the People without any of amendments recommended by Council of State. Clause 5 of Article 109. If a money bill passed by the Oh man, I was just rambling and sorry, the mic was off. What a stupid me, man. So Om Birla has right to make decision on whether a bill is money bill or not. If there is a debate, his decision will be final. Om Birla's decision. Clause 4 of Article 110. There shall be interest on every money bill when it is transmitted to the Council of State under Article 109 and when it is presented to the President for assent under Article 111. The certificate of the Speaker of the House of the People assigned by him, that is money bill. Article 111 assent to bills. When a bill has been passed by the Houses of Parliament, it shall be presented to the President, and the President shall declare either that he assent to the bill or that he withholds assent therefrom. Okay, what is assent? What does assent mean? I don't know. Okay, so this is the President gives approval, not. Okay, this is a very strong law, man. Like, if a president wants to stop it, he can. Okay, provided that president may as soon as possible after the presentation of him up a bill or assent return the bill if it is not a money bill to the houses with the message requesting that they will reconsider the bill or any specified provision thereof and in particular will consider the desirability of introducing or any such amendments as he may recommend in his message, and when a bill is so written, the Houses shall reconsider the bill accordingly. And if the bill is passed again by the Houses with or without amendment and present to the President for assent, the President shall not withhold the assent therefrom. Okay, so the President's choice goes away for the second time actually. Yeah, thank you. Article 112 Annual Financial Statement Clause 1 The President shall in respect of every financial year cause to be laid before both the Houses of Parliament a statement for the estimated receipts and expenditure of the Government of India for that year in this part referred to as the annual financial statement. Clause 2 of Article 112 The estimates of expenditure embodied in the annual financial statement shall show separately a. The sums required to meet expenditure described by this constitution as expenditure charged upon the Consolidated Fund of India and b. The sums required to meet other expenditure proposed to be made from Consolidated Fund of India and shall distinguish expenditure on revenue account from other expenditure. Clause 3 of 112 The following expenditure shall be expenditure charged on the Consolidated Fund of India. The emoluments and allowances of President and other expenditure relating to his office. Subclause B. The salaries and allowances of the chairman and the deputy chairman of the Council of State and the speaker and the deputy speaker of the House of the People. The debt charges for which the government of India is liable, including interest, sinking fund charges, and redemption charges, and other expenditure relating to the raising of loans and the service and redemption of debt. DI. The salaries, allowances, and pensions payable to or in respect of judges of the Supreme Court. The pension payable to or in respect of judges of the Federal Court. 3. The pension payable to or in respect of judges of any high court which exercises jurisdiction in relation to any area included in the territory of India, which at any time before the commencement of this constitution exercised jurisdiction, jurisdiction, jurisdiction in relation to any area included in governance province, governance province of the Dominion of India. E. The salary allowance and pension payable to or in respect of the Comptroller and Auditor General of India. F. Any sums required to satisfy any judgment, decree, or award of any court or arbitral tribunal. G. Any other expenditure declared by this Constitution or by Parliament by law to be charged. Article 113. Procedure in Parliament with respect to estimates. Clause 1. So much of the estimate as relate to the expenditure charged upon the Consolidated Fund of India shall not be submitted to the vote of Parliament, but nothing in the clause shall be construed as preventing the discussion in either House of Parliament of any of those estimates. Article 113. Clause 2. So much of the said estimate as relate to the other expenditure shall be submitted in the form of demands or grants to the House of the People, and the House of the People shall have power to assent or to refuse assent to demand or to assent any demand subject to a reduction of the amount of specified therein. Okay, this is hard, man. This is clause 3. No demand for grant shall be made except on the recommendation of the President. 114 Appropriation Bills. Article 114 Appropriation Bills. Clause 1. As soon as may be after the grants under Article 113 have been made by the House of the People, there shall be introduce a bill to provide for the appropriation out of the Consolidated Fund of India of all monies required to meet. Clause A. Subclause A of Clause 1. The grants so made by the House of the People, and B. The expenditure charged on the Consolidated Fund of India but not exceeding in any case the amount shown in the statement previously laid before Parliament. No amendment shall be proposed to any such bill in either House of Parliament which will have the effect of varying the amount of altering the destination of any grant so made or of varying the amount of any expenditure charged on the Consolidated Fund of India and the decision of the person presiding as to whether an amendment is indismissible under this clause shall be final. Clause 3. Subject to the provisions of Articles 115 and 116, no money shall be withdrawn from Consolidated Fund of India except under appropriation made by law passed in accordance with provision of this article. 11 Article 115. Supplementary, additional, or excess grants. The President shall, Clause A, if amount authorized by any law made in accordance with provisions of Article 114 to be expended for particular service for the current financial is found to be insufficient for the purposes of that year, or when a need has arisen during the current financial year for the supplementary or additional expenditure upon some new service not contemplated in annual financial statement for that year, or if any money has been spent on service during a financial year in excess of amount granted that service and for that year. Cost to be laid before both houses of parliament. Another statement showing the estimated amount of the expenditure or cost to be presented to the House of People. A demand for such excess as the case may be. Okay, so the president spends more money than the it was planned in the financial budget. You have to present the things before the House of Parliament and House of the People, Rajya Sabha and Lok Sabha. Article 115, Clause 2. The provisions of Articles 112, 113, and 114 shall have effect in relation to any statement and expenditure or demand, and also to any law to be made authorizing the appropriation of monies out of Consolidated Fund of India to meet such expenditure or the grant in respect of such demand as they have effect in relation to the annual financial statement and the expenditure mentioned therein, or to a demand for a grant and the law to be made for the authorization of appropriation of monies out of the Consolidated Fund of India to meet such expenditure or grant. Okay. Article 116. Votes on account, votes of credit and exceptional grants. Clause 1. Notwithstanding anything in the foregoing provision of this chapter, the House of People shall have power, subclause A, to make any grant in advance in respect of the estimated expenditure for part of any financial year pending the completion of the procedure prescribed in Article 113 for the voting of such grant and the passing of the law according with the provision of Article 114 in relation to that expenditure. Subclause B. To make a grant for meeting an unexpected demand upon the resources of India when on account of the magnitude or the indefinite character of the service the demand cannot be stated with the details ordinarily given in an annual financial statement. See, to make an exceptional grant which forms no part of the current service of any financial year. Okay. And Parliament shall have power to authorize by law the withdrawal of monies from the Consolidated Fund of India for the purposes for which the said grants are made. Clause 2. The provision of Articles 113 and 114 shall have effect in relation to the making of any grant under Clause 1 and to any law to be made under that clause as they have effect in relation to making of a grant with regard to any expenditure mentioned in the annual financial statement and the law to be made for the authorization or appropriation of monies out of the Consolidated Fund of India to meet such expenditure. Article 117 Special provision as to financial bills. Clause 1. A bill or amendment making provisions for any of the matters specified in subclauses A to F of Clause 1 of Article 110 shall not be introduced or moved except on the recommendation of the President, and bill making such provision shall not be introduced in the Council of States, provided that no recommendation shall be required under this clause for the making of an amendment making provision for the reduction or abolition of any tax. Clause 2 of Article 117. A bill or amendment shall not be deemed make provision for any of the matters aforesaid by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees, or licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration, or regulation of any tax by any local authority or body for local purposes. 3. Clause 3 of Article 117. A bill which, if enacted and brought into operation, would involve expenditure from the Consolidated Fund of India, shall not be passed by either House of Parliament unless the President has recommended to the House of the consideration of the bill. Procedure generally. Okay, so this new thing is gonna be starting and we are gonna drop the stream here. I also wanted to check if the stream crashes or not, and it has gone for solid 40 minutes. I think the crashing